So, the Paul Ongili, Babu Owino.
I do appear alongside the learned colleague, Mr. Embakasi. I equally hold brief for Mr. Magoya. Unfortunately, not with us this afternoon, but I'll hold his brief. We all appear for this person.
Yes.
We are ready to take the decision in such a short time.
So this is a judgment. I may not be able to read the entire judgment, but accused Paul Ongili Babu Owino was initially charged with the two counts. In count one, he had been charged with the offense of attempted murder, contrary to section 220 of the Penal Code. And the particulars were that on 17th January at a B Club, Galana Plaza in Kilimani area, he unlawfully attempted to cause the death of Felix Orinda by shooting him on the neck. This charge was compromised, and it was withdrawn under section 204 CPC on the 14th of December 2021. In the second count, which is a charge facing the accused now before this court, the accused is charged with the offense of behaving disorderly while carrying a firearm, and the particulars of the offense are that on the 17th day of January 2020 at B Club, Galana Plaza in Kilimani area within Nairobi County, while carrying a firearm, make a style pistol, serial number 3159039, he became disorderly and fired one round of ammunition with intent to shoot Felix Orinda. In support of the charges, the prosecution called a total of 10 witnesses, who included George Otieno Mburi, security manager at B Club the particular day, Godfrey Mwai, the manager of both B Club at Kilimani and Gossip Club at Lavington on the particular day, one Derek Globa Makoa, a driver working at B Club. On the material day, who testified that he helped take the victim to hospital, the guard on duty on the material day guarding the accused person. The other witness is Felix Ochoi, who testified that he was a patron at B Club on the material day. He stated that the other witness is Flora Chow, a security officer at the club, was to ensure that the patrons entering the bar did not carry dangerous items and drinks from outside. And who stated that she saw the accused person enter the club on the material day. PW as a waiter, and stated that he was one who was serving the accused person on the material day. The eighth witness is Inspector Robert Kiptumbet from DCI, from DCI Ballistic Forensic Section, and a firearm examiner. He prepared a report which he produced in court as exhibit after taken to him for examination. The ninth witness is Chief Inspector George Aringo from Cybercrime Forensic Unit, a CCTV footage from Big Club for the material day. And the last witness is Koplo Dennis Mieso, one of the investigating officers of Sergeant Moria and the DCI Kilimani, 1 Katuma. Evidence of all these witnesses in details in my judgment, but the prosecution case, the court found that the accused person had a case to answer, and the accused person chose to give sworn evidence. He called 4 other witnesses. And in his defense in brief, he denied that he shot the accused, and stated that there was no witness who saw him direct his gun to Felix Orinda. I have also analyzed this evidence in full in my judgment, but I will not read out the entire evidence of the accused person, but it is in my judgment. The other witnesses called by the accused person are Felix Orinda, the victim in this matter, who testified that he was a DJ by profession, and was working at B Club at the time. He stated that he interacted with the accused person, Babu Owino, who was a friend of his for a long time. He stated that on the material day there had no squabbles, that while having a conversation with him, he had a gunshot which caused injuries to him, but stated that he did not see the accused person with a gun. He stated that the lights had been turned down, and therefore it was a bit dark, and he did not see where the gunshot came from. He stated that he later learned that the accused person held him to hospital. He stated that the accused person had been supporting him by taking care of his hospital bills, his utilities, and well-being from the time the incidents happened. The other witness is Edwin Gandhi Otieno, a personal assistant of the accused person, who testified as to what happened on the material day and the day before. But the 4th witness was one Charles Ocheng Otieno, a security officer also employed at B Club. He stated that he was the one who used to handle guns that were left by patrons who visited the club while armed, and testified that on the 16th of January 2020 at around 11 p.m., the accused person arrived at the club with his security people, and that he deposited his firearm with him. He stated that around 7 a.m. while in his office, he saw the accused person being assisted by someone to carry another person to the parking area, that he went to the armory and took the accused firearm, which he released to him. The last witness for the defense is Henry Owino Jode, who testified that he was a cleaner at Gossip Club, and he, on the 17th of January, he was at the club at around 7 a.m. with his boss, Godfrey Mwai, who requested him to accompany him to B Club, where he had been called to. And when they arrived at the club, they found the accused, Babu Owino, at the parking with DJ Elvove, who appeared sick, and that the accused person requested them to escort or to take them to hospital. After the close of the defense case, the defense filed written submissions, while the prosecution chose to rely on the evidence on record. The defense identified 2 issues for determination. First, whether the accused person was behaving disorderly, and second, whether the accused fired 1 shot with intent to kill the victim. On the first issue, the defense cited Black's Law Dictionary on the definition of disorderly, which is described as a manner that is contrary to the rules of that the accused had visited the club with the intention of having a meeting and hanging out with his friends. And throughout the entire night, none of the witnesses, including the prosecution witnesses, could testify to the effect that the accused was disorderly. The defense admitted that the prosecution failed to adduce any evidence to support the allegation that the accused was disorderly, that in fact, contrary to the famous belief, the accused person actually consented to taking a blood test for the purpose of establishing the level of alcohol in the system, but the report never saw the light of the day. They further submitted that several items were collected and swabs were taken with a view to confirm the intoxication status of the accused, but a report was never produced from the government chemist on the analysis. The defense submitted that had the report been produced, it would have found that the accused was not intoxicated as alleged, and that is the reason the prosecution failed to avail the report. The defense relied on the case of Patrick Mutungi Njue versus Republic, where the learned judge held that in a charge under Section 33(1) of the Penal Code, it was not enough for the prosecution to adduce evidence of disorderly conduct, but must prove that the person was drunk and that the arresting officers had the obligation to take the blood samples of the accused and take it for testing of the alcohol content, which was not done in this particular case. That there was no single witness who corroborated the allegation that the accused fired one shot with the intention to shoot Felix Orinda. The defense also submitted that the ballistic expert could not determine whether the recovered bullet from the scene was a match to that from the accused firearm. The defense admitted that evidence on record was clear that at the time of the alleged offense, the accused was not in possession of his firearm, which was deposited at the armory of the club, and the victim himself testified that he had been friends with the accused over the years, and as such had no motive to shoot him. The defense further submitted that the accused showed that his gun was faulty on the particular day after it had jammed at the shooting range the previous day, and therefore he could not have fired the victim. The defense further submitted that the standard of proof in criminal cases in Kenya was proof beyond reasonable doubt, and the prosecution had failed to prove its case to the required standard. The defense relied on the case of Wilmington versus DPP 1935 AC 462 to underscore what proof beyond reasonable doubt meant. In regard to the CCTV footage that was produced in court, the defense admitted that the same had lost its evidentiary value and remains unreliable and inadmissible. The court ought not to attach any probative value to the same as per Section 106B(4) of the Evidence Act. Regarding the certificate of electronic evidence produced by PW9, the defense admitted that the same was electronically signed and the witness did not have a certificate of electronic evidence, the electronic signature as provided under Section 106C of the Evidence Act. The defense also submitted that the witnesses testified that the CCTV footage was initially stored in a flash disk before being certificate. The defense took issue with the fact that the CCTV footage of what allegedly transpired had been circulated to the social media before the investigating officer got hold of it. It was not clear how it had been obtained from the club. The officer collected the same. They also submitted that the network video recorder was also not produced in court as exhibit. The defense submitted that PW9 was not the custodian of the CCTV equipment from where the CCTV was extracted, and they could not vouch that the same were in proper and good condition. They also submitted that PW9 admitted that he could not see any gun from the CCTV footage that he was producing. In conclusion, when the firearm examiner concluded that the fatal bullet was discharged from a gun that was different from the one which the accused had. The defense submitted that the prosecution failed to avail evidence to show the accused was drunk, and that the evidence of the waiter serving the accused is of the accused person. The description given in the first part of Section 33 of the Act is that the person must be drunk. It is not enough for the prosecution to adduce evidence of disorderly conduct, but must prove that the person was drunk. The arresting officers were under an obligation to cause to be taken a blood sample of the accused and take it for testing of alcohol content. None of the prosecution witnesses, including the investigating officer, spoke of the state of the accused, whether he was drunk or not. In the case of Patrick Njue versus, but in my view, the images on a CCTV footage or statement by the victim that he was shot cannot be substitute for medical evidence. The primary evidence that ought to have been produced to prove the victim was shot by a gun was the medical report or a duly filled P3 form to confirm that the victim had suffered a gunshot wound. The court cannot be left to rely on conjecture. In any event, when the court looked at the CCTV footage that was played in court, the background was quite dark, though the counter where the accused was standing with some people was a bit clear. The accused person could be seen from the clip as he was talking to several people around him while smoking what appears like shisha. The view is mainly of the accused's left side of the body, while the right side is on the dark side and cannot be seen clearly. A certain lady in a brown jacket appears on the left side of the accused person and prevents a full view of what exactly the accused was doing, save when he intermittently moved back and forward. During the conversation at one point with the people around him, the accused points something towards the other side, which is dark. Someone falls near him shortly afterwards. The clip did not come with sound, and therefore there was no sound heard of what exactly transpired. From the clip, you cannot tell with certainty that what was pointed by the accused to the dark side of that area was a firearm, and it is not clear where the accused got the object. In fact, the investigating officer on cross-examination stated that he could not be able to see or identify the accused's gun from the clip. As stated above, the investigating officer in his testimony states that prior to this, the accused was arguing with Felix Orinda, the victim. He, however, did not state what they were arguing about or how he got this information, as the clip did not capture Felix Orinda until the time was being picked from the ground and being taken out of the building. In the absence of any other witness who would give an oral account of what transpired, I believe that the evidence of Felix Orinda himself is very crucial evidence, as he was a victim of the said shooting and could have seen what transpired before the incident. Surprisingly, the said Felix Orinda, who was expected to be a key witness for the state, as even confirmed by the investigating officer, was not a prosecution witness. In fact, the investigating officer on cross-examination stated that he did not record a statement from Felix Orinda, the victim of the alleged shooting. And one wonders whether it was deliberate or a case of negligence, as he did not state that the said Felix, he did not state that he approached the said victim for purposes of recording a statement from him and refused. The said victim, however, turned out to be a key witness for the defense. In his testimony, he testified that before the incident, he was talking with the accused and did not see him with a gun. He also stated that he had no squabbles with him and that they did not quarrel. He stated that he suddenly had a gunshot which hit him, but could not tell from where it was fired. He, however, stated that he was told that the accused took him to hospital. The evidence of the victim therefore discredited that of the investigating officer. Having failed to adduce evidence that the victim was injured by a bullet wound, the next question then is whether the ballistic expert report links the accused person to the offense. It is noted that the prosecution alleges that a bullet head and a spent cartridge were recovered from the scene. The investigating officer stated that he was not the one who recovered them and could not recall who recovered them. He, however, stated that the bullet head was recovered from a wall at the scene. He did not state the location of the wall from where the bullet head was recovered and the distance from where the victim was lying. My question would be, why did the investigating officer not avail the person who recovered the bullet head and cartridge in court to testify? Was it not necessary to confirm that they were found at the scene where the alleged incident happened and confirm that they were from the accused firearm? If the bullet head was recovered on the wall as claimed, was it not necessary for the ballistic expert to visit the scene and adduce evidence on the possible trajectory from the point where the victim was shot? Was it not necessary to avail medical evidence to show that once the victim was shot, the bullet actually exited from the body of the victim and could have landed on the wall as claimed? Having seen the CCTV footage, was it not necessary to avail evidence to show that from the angle the accused was standing, it was possible to recover the bullet from the wall where it was allegedly recovered? These, to me, are important questions which ought to have been considered and addressed by the investigating officer during investigations. And this is where I reiterate that the investigations herein were shoddy, as very crucial areas were not covered. It cannot also be denied that bullet wounds can provide some information about the type of firearm used, caliber, bullet type, and trajectory after the incidents. And the investigating officer ought to have availed this evidence. In his testimony, the investigating officer testified that the recovered bullet head and the cartridge, together with the accused firearm, a pistol serial number 3159039, a magazine and 9 rounds of ammunition, were forwarded to the ballistic expert for analysis. PW8 is a ballistic officer and testified in respect of the examination and analysis he conducted on the exhibits mentioned above. He stated that he examined the exhibits and confirmed that the exhibit marked A and exhibits marked C1 to C9 were firearm and ammunition, respectively, and were capable of firing and being fired. He also stated that the ammunition were caliber 9 by 19 millimeters. He also formed the opinion upon analysis of the recovered spent cartridges case that it was found to be in caliber 9 by 19 millimeters and had sufficient breeze face markings, ejector markings, and firing pin identification, which enabled him form an opinion that it was fired from a Mannlicher pistol, like that one of the accused person. In regard to the recovered bullet head, he stated that upon examination, it bore 6 identifiable land engraved areas similar to those found in the accused's gun. He, however, stated on cross-examination that he could not tell whether the recovered bullet head and cartridge case were related. He could also not tell whether the bullet head that was recovered and marked E was shot from the accused's gun. He admitted on further cross-examination that there were many firearms which could use a 9 by 19 millimeter ammunition, like Seska pistols, Glock pistols, Smith and Wesson, etc. The net effect of the evidence of the ballistic officer's evidence was that though the accused's firearm may have been used to fire the recovered cartridge and recovered bullet, there was a possibility of other firearms doing the same, and therefore could not conclusively find that the accused's gun could have was one that fired the recovered bullet head and the cartridge. It was upon the investigating officer, therefore, to avail collaborative evidence, as the evidence by the ballistic officer could not stand on its own. Having evaluated the evidence available before me and applying the relevant test, it is my finding that the prosecution has not proved its case beyond reasonable doubt. In summary, point out the following factors for the so finding. Evidence presented to show that the state of sobriety or otherwise of the accused in the allegation of being disorderly. The victim, the victim of the alleged offense denied that he quarreled with the accused and that the accused shot him. C, no medical evidence was presented to show that the accused person, the victim, had been injured by a gunshot. And finally, the ballistic expert did not conclusively find that the accused's firearm was the one used in the act. For the above stated reasons, the accused is found not guilty and is acquitted under Section 215 CPC. And in conclusion, the court notes that this is a case of great public interest that may have gone wrong during investigations, and perhaps the DCI should consider such cases being investigated in future by senior experienced officers, at least in the rank of Inspector of Police and above. So that is the judgment of the court.
time you have taken to come up with a very extensive wise judgment, actually. And Your Honor, we believe that justice has actually been done. And we are grateful to the court because we know this is not the only case on your table. But we are grateful that the time you have taken have actually helped not only us but future practitioners, Your Honor. In terms of the issues that you are dealing with. Your Honor, for the defense, I think the only word we remember is that the accused is not guilty, and he has been acquitted under Section 15. At least that, for us, is our take home. But I know that with the sentiments you expressed, both to the prosecution and to the Directorate of Criminal Investigations, it will help in advancing the cause of justice. But we believe justice has been done in this particular matter. Your Honor, I have an application to make.
Yes.
I have an application to make, Your Honor. Your Honor, we want to request the court to make an order Your Honor, for the release of the cash bail that was deposited in this particular court. Your Honor, would also equally make a request that you make an order that the passport that was deposited that belongs to the accused person be released to him forthwith. It has really been hard for him to represent his people because sometimes it requires benchmarking here and there. So we'll be grateful for that. Your Honor, we will also equally make a request that the firearm that was presented in court as exhibit, the ammunition, the firearm certificate, be released to the accused person. Your Honor, maybe you can give, you can say it be released within a certain time frame, maybe to allow the processing. Your Honor, I will give to my learned colleague to just give some final sentiments.
Yes, Your Honor. Again, we are grateful for the work that the court has delivered. And despite the outcome of the judgment, we appear before you, Your Honor, that the victim is a great threat to the Member of Parliament.
Off the record, as I was speaking to my client, Your Honor, he's happy that he has had his day in court, Your Honor. We are living in a day where decision seems that it will always be made somewhere whether you are guilty, and you are told you'll be given three choices: either to fly out of your country, either to decide to be in jail directly, or either you are given cotton wool and you are sent to your maker. So we are we are happy that through this you are proving that there is a process through which these things can be followed before that decision is made by someone else.
The prosecutor.
On behalf of the state, I wish to thank the defense in counting the court for the time it has taken not only to deliver accommodated us through the many intricacies in this matter, but of interest, and we will bring for appropriate. Further, Your Honor, with regards to the application which has been made for the release of the firearm, the ammunition, and the firearm certificate, Your Honor, that application can be revisited in 14 days, and the right of appeal is extinguished. Because the state is here to communicate, I'm yet to get a copy of the judgment and communicate the same to the person holding the office of the DPP currently, to get further instructions in the matter.
I direct that the matter after the 13th of September, when the court can give directions on the same. So you can propose a date formation after 13th of September. That's okay. So the passport will be released alongside the cash bill. So the court is adjourned.